In this lesson, we will see a compliance memo specimen. Date, Saturday, March 28, 2026, prepared by Your Name Compliance Officer. Subject: Compliance Assessment Authority Termination of Relationship with Sanctioned Entities. Executive Summary: This memo evaluates the legal and compliance risks associated with the termination of a business relationship with entity name, in light of conflicting obligations under US, EU, and UK sanctions regimes. The termination decision is justified based on specific commercial reasons, e.g., credit risk, operational restructuring, with all actions documented to ensure regulatory defense and audit readiness. 2. Factual background: entity name, name of counterparty, nature of relationship, type of contractual or financial relationship, relevant jurisdictions, list jurisdictions, e.g., US, EU, UK sanctions status. Describe whether the entity is on the US SDN list, EU consolidated list, UK sanctions list, etc. Key dates: provide relevant dates for the transaction or relationship. 3. Legal framework: SUDIAMP, regulatory obligations. A. U.S. sanctions. OFAC entity name is subject to secondary sanctions under e.g. COTSA, Helms-Burton Act, with risks of penalties including SDN designation or exclusion from the U.S. financial system. The OFAC 50% rule applies as entity name is 50% or more owned by an SDN. B. EU blocking statute under Council Regulation EC No. 2271/986, entity names relationship is protected, and compliance with extraterritorial U.S. sanctions is prohibited unless EU Commission authorization is obtained. C. UK sanctions. OFC entity name is not listed under OFC's UK sanctions list. However, indirect ownership or control may create exposure. 4. Risk assessment: A. Legal risks: U.S. compliance risk. Non-termination risks: US enforcement actions, including fines or exclusion from US markets. EU legal risk: termination risks violating the EU blocking statute unless justified by unrelated commercial grounds. BC commercial risks: outline financial or operational risks, e.g. credit risk, reputational harm, supply chain disruption. V. Recommendations: seek EU Commission authorization. Submit a request under Article 5(2) of the blocking statute. Acknowledging the rarity of approvals. Document commercial justifications. Justify termination based on credit risk, operational restructuring, or other valid commercial factors unrelated to sanctions. Ring-fence operations. If feasible, restructure to separate US and EU operations to mitigate conflicting obligations. Apply for OFAC license. Submit a license application to OFAC to continue the relationship, ensuring compliance with US regulations. Maintain records. Retain detailed documentation for audit and regulatory defense, including risk assessments, correspondence, and legal advice. 6. Conclusion: the termination of the relationship with entity name is recommended based on commercial and risk-based considerations. By seeking EU authorization, documenting justifications, and maintaining compliance with US, EU, and UK frameworks, the company minimizes legal and regulatory exposure while preserving operational integrity. Approved by Name of Compliance Head. Date: March 28, 2026. Attachments: Screening results, risk assessment summary, applicable legal frameworks, draft EU authorization request. Disclaimer: this compliance memo is for internal use only and is based on the information available as of the date above. Regulatory advice should be sought for further clarification.